Streaming live via the internet. Welcome to ISP Radio, your weekly source for ISP-related news, events, and interviews with industry experts. If you deliver internet via fiber optic, wireless, coax, or any other way, you're in the right place. Chat live with us weekly via ispradio.com every Wednesday at 11 a.m. Central Time. And now a brief word from our sponsors. Link Technologies, providing ISP consulting, support, and hardware for wireless ISPs. TowerCoverage.com, providing online RF coverage maps. And now your host for ISP Radio, Steve Grabiel and Dennis Burgess.
Welcome to another edition of ISP Radio, the edition that was supposed to happen yesterday, but due to technical difficulties, we're doing it today. That's okay. We are fortunate to have on the show again Alex Phillips with High Speed Links. He's the president of WISPA, and Steve Coran, WISPA's attorney at large, or attorney general, if you will, with the Lurman Center. And let's just get back into it and skip the short talk. And Steve, we start back in from the beginning of where you were going yesterday?
I'll give it a try, Steve. Thanks very much, and happy that we're able to all get back together again.
Absolutely.
So, as folks recall, in February of 2015, the FCC adopted a very controversial order that applied Title II of the Communications Act to broadband internet access service providers. And Title II is the part of the act that deals with common carriers. The FCC reclassified broadband providers from being information service providers, which has enjoyed a light touch regulatory approach for several years, to become these heavily regulated Title II providers subject to a bunch of common carrier rules, although the FCC did decide to forbear from enforcing a number of those rules. So that was immediately appealed to the courts, and after some back and forth, it was decided that the District of Columbia Court of Appeals would hear the case. That was favored by many litigants because of their expertise in resolving the two previous cases, the Comcast case and then the Verizon case that remanded in 2014, remanded the case to the FCC. There were three separate lawsuits that were filed. The first one was a group that included WISPA, U.S. Telecom, NCTA, American Cable Association, AT&T, CenturyLink, and I may be leaving one of them out. A second lawsuit was filed by Alamo Broadband and one other person, and alleged that the FCC's rules violated the First Amendment to free speech. And then the third was filed by some CLECs, and they thought the FCC's rules should apply without forbearance. In other words, the full force of all of Title II rules should be applied to broadband providers because the FCC had not justified its decision. So in December, after briefs were filed by all parties, there was oral argument in front of a three-judge panel at the D.C. Court of Appeals. Judge Tatel, who had written the previous decision, the Verizon decision, was front and center and regarded as very knowledgeable on these sorts of issues. The other two were Judge Srinivasan, who was appointed, I believe, by President Obama, and so in December, Judge Williams, after briefs were filed, by all parties, who was appointed, I believe, by President Reagan. So that was our panel. In June, just last month, the court reached its decision, and all three judges agreed that the FCC had authority to reclassify broadband providers as Title II common carriers. This is because the statute and the resolution was ambiguous, and in those cases, the courts give the agency a high degree of deference under an old case called Chevron, a Supreme Court case that gives federal agencies deference to make decisions given their alleged expertise in the particular subject matter. So that was the initial conclusion that all three judges agreed on. But from there was a point of departure, and on the remaining issues, it was 2-1 in favor of the FCC on all points, and Judges Tatel and Srinivasan were the two. Judge Williams, the senior judge, was the one-man minority, and really very interesting and opposing views that you see when you read the decision. First off, the two judges in the majority agreed that the FCC had provided adequate notice that it was considering reclassification to Title II. One of the claims that WISPA and the other petitioners brought was that the FCC may have mentioned Title II, but never really indicated that it was going to apply it and to reclassify, and that was something that came up later. And the court said, well, the fact that the FCC kind of mentioned this in its notice of proposed rulemaking means that the reclassification was, quote, a logical outgrowth of what was in the NPRM, and that therefore the FCC had provided adequate notice. A second issue is whether the FCC had adequately justified a change in its legal policy and had established a factual basis for that change as well. And that meaning a change from information service providers to common carrier telecommunication service providers. And here again, the court disagreed. The majority said the FCC had done enough. We're not here to sit in judgment as to whether we agree with the reasons or not, but they attempted to explain the rationale for their decision. Judge Williams, on the other hand, said, they did not really do what they needed to do in order to justify the factual change in legal policy from information service to telecommunication service, nor in the factual case, and just saying that people buy internet differently now than they have forever after 17 years of cases saying it's an information service was insufficient. One other point is that the FCC had adopted something called the Internet Conduct Standard, which basically says the FCC can look at any practice that you are undertaking and decide whether it is unreasonably interferes or unreasonably disadvantages other folks in the internet ecosystem, whether it's consumers or edge providers. And the FCC had come up with 7 non-exhaustive factors that it might look at. The two-judge majority said we're fine, this is not vague. Judge Williams said, well, the fact that this is non-exhaustive and the fact that you have 7 factors that they might look at and you haven't really defined what you mean by unreasonably interfere or unreasonably disadvantage, I think this is pretty vague. So the court also said that the FCC's interconnection, its one-sided review of interconnection negotiations and also application of these rules to mobile service providers, the FCC had met its standard for those. So that's kind of where the decision ended up in June.
Wow, that's like a whole lot of stuff. So right now, the big thing that I think most of our listeners are interested in is currently we have forbearance on a number of exemptions for small business, and that runs out when?
So let me kind of say it a different way. One of the things the FCC did in February of 2015, and WISPA and the small cable guys were in favor of this, is they adopted a temporary exemption from a small subset of these rules. And that small subset is enhanced disclosure requirements about what your open internet policies are. So right now, based on the 2010 FCC's order, all broadband providers, including every single WISP, regardless of size, has a certain obligation to disclose things about its pricing, about its congestion management policies, where consumers can file complaints, what your complaint resolution process is, what your speeds are, where you have to display this information. What the FCC did in 2015 is they enhanced and clarified a number of these requirements. And WISPA was able to get from the FCC an exemption for broadband providers with fewer than 100,000 customers, or actually subscribers, subscriber lines, actually IP addresses, connections, from those new requirements, but not the old ones. So that exemption was going to expire at the end of 2016, and on the eve of the FCC's of the sunset of those rules, the FCC kicked it down the road to December 2017. I'm sorry, 2016. So we have a one-year extension from December 2015 to December of 2016. So meanwhile, Congress has gotten involved, and again, WISPA and other trade associations are leading that effort. And in February, by a 411-0 vote, the House of Representatives voted to extend that temporary exemption for 5 years and increase the number to 250,000 customers. So we thought we were doing really well because it had sailed through the House, and then it got bogged down in the Senate. And as we all know, the Senate is shut down while it attends conventions and does their political campaigning during August. So it looks like September will be the next opportunity to pick that up again. And please don't ask me about the way that Congress works on these things, but it's gone a little bit back and forth, and certain senators have had issues with it. They don't like it. They want to change the numbers. If you change the numbers and it differs from the House bill, it has to go to a conference. So there's just been a lot of twists and turns on the roads on something that should have been fairly easy. So one more point to all this is that the enhanced disclosure requirements don't even apply yet to the big carriers, and that's because, and folks out there will love this, these rules are subject to something called the Paperwork Reduction Act, which means that the Office of Management and Budget has to approve any information collection, which this is, before the rules can become effective. Well, the FCC has to put out for public comment a notice saying, here's what we think the estimated burdens of compliance are. So the FCC did this, and everybody, every single association, WISPA, US Telecom, American Cable Association, NCTA, CTIA, all jumped it and said, you've got to be kidding. These estimates are ridiculous. They're unreliable. They're way too low. You guys need to go back to the drawing board. So the FCC said they would do that, but they haven't yet put out another notice for comment. So that's where we stand on just the open internet enhanced disclosure requirements. But all the rules that are, I think, most important to the appeal are the three what we call bright line rules: no blocking, no throttling, and no paid prioritization. And the first two are subject to reasonable network management. Talk to your lawyer and your engineers about what that means. Paid prioritization, however, does not have that qualifier or subject to language. So no paid prioritization, keywords being paid, and that's what's kind of led to a discussion about zero rating and things like that.
So yeah, that's the follow-ups with Steve's statements about that. You know, we did have some good successes back in the spring with the House of Representatives on their bill, 4596, and you know the terms were 250 subscribers, and it had a 5-year sunset. And so we felt that when it got introduced into the Senate by Senator Daines, which is Bill 2283, that we had a good opportunity to get it pushed through as well. However, there was a lot of pushback from Senator Cantwell. Wanted to see it go back to a smaller subscriber base and reduce the term of the extension just to 2 years. And so with our work with our lobbyists and some of our allies in the trade industries, we were able to get that Senate bill, you know, reworked to back up to 250,000 in a 3-year term. And the nice part about that, even though it was a shorter term, is that if the FCC does fail to do their burden analysis, which Steve was referring to, it will automatically start over again for another term. So we felt like that had a pretty good opportunity for us to get that carve out potentially for a longer period after that. The problem now, and that is since it's passed to that Senate committee, is that Senator Nelson from Florida has sort of blocked it from getting onto the floor. And when we talk with him, he says he's not really against it. His reason was he was hoping to leverage it in the fall when they reconvene the Senate for his agenda for the telecommunications forward project he's working on. So we're just going to have to kind of hold tight until then. Although anyone listening to this, and as a WISPA member or otherwise engaged in this particular activity that would like to see this bill passed, I suggest you write or contact or email your senator and reference the Senate Bill 2283 and show your support for it getting passed, because that's really going to be important for us to have that in place. Now, we've talked about some of the things with Title II that we're having to deal with, and there's some side effects that I'm going to ask Steve to talk a little bit about regarding now that the FCC has dominion over regulations and things like that regarding what we do with our businesses. And they've introduced some new privacy regulations and some outage reporting regulations, which are going to be very burdensome from our perspective. And Steve, do you want to kind of explain a little bit about how this has evolved and what we're doing about that?
Sure. One of the things that the FCC said in its order in 2015 was that we're going to enforce Section 222 of the Communications Act, even though we don't have rules. And Section 222 effectively asked the FCC to implement privacy rules called CPNI, which is applicable to voice carriers and interconnected VoIP in particular, and those WISPs who provide VoIP, and any carrier that provides voice has to file a certification on March 1st of every year that talks about their compliance with Customer Proprietary Network Information, or CPNI rules. So the FCC said, we're going to enforce the statute and just do the best you can until we come up with a rulemaking proceeding. So that's what the FCC did. They adopted a notice of proposed rulemaking a few months ago, and it didn't look at all like the CPNI rules. In fact, it seeks to protect a lot of other information, something called personally identifiable information. It does not include edge providers. And let me back up a little bit, because the FTC, the Federal Trade Commission, has had primary jurisdiction over privacy breaches under a statute that regulates unfair and deceptive trade practices. It's a very general and flexible statute. But the FTC does not have jurisdiction over common carriers. So when the FCC exercised its apparent right to reclassify broadband providers as common carriers, it took that authority away from the FTC, and now it seeks to greatly expand what broadband providers would be required to do. I won't go into all the details. I mentioned it doesn't include edge providers. It greatly expands the amount of information that would be required to be protected. It has an opt-in, an opt-out, and an implied consent, kind of three-part way of protecting information. There's no small business carve-out at all that the FCC has proposed. You would need to disclose, if the FCC's rules went into effect, any breach, even if it was unintentional, and even if no consumer suffered any harm at all. There would be very quick turnarounds in terms of 7-day notices of breaches to the FBI and the FCC, and 10-day notices to affected customers, which is much quicker than any state currently requires. So you also have state privacy obligations. So it has been, you can imagine that the public interest advocates are on one side and pretty much everybody else is on the other side, saying that the FCC doesn't have authority to go beyond CPNI, but should apply CPNI in a very flexible way. And The rules are overly prescriptive, overly broad, incredibly costly, and burdensome. It's been estimated that it would cost $150 per customer every time there's a breach, and cost of that, if you have 500 customers, just do the math, that's $150,000 a year. I'm sorry, $75,000 a year. And I think if most WISPs had $75,000, they could probably, and 500 customers, they could probably use that to put up a couple of more access points and maybe double the size of their networks. But the
Just a
FCC
few.
is saying,
Yeah.
well, they don't know this because they didn't ask us and they didn't do the research. We would much rather have you implement these rules and hire people and get the expertise and hire the lawyers and the engineers and the privacy experts to train your staff to do all this stuff so you can maintain your existing customers instead of going out there and using that same money to double the size of your customers. So what did WISPA do? We asked the FCC to defer the implementation of these rules by a year or two, to take the size of the broadband provider into account when it looks at these rules, and to exempt small providers from certain of these rules. So I'll close by saying that the FTC has even said that this outcome is not optimal, quote unquote, when it specifically commented on the FCC's proposed rules.
It's really interesting information, and I'm glad that WISPA is doing everything they are to keep things going. Alex, I wanted to go back to the legislative update that you had kind of said, and you had asked that people, write their senators and help out in ways they can to help us with these issues. I'm pretty sure that if you need to, you can contact the legislative committee and just say, hey, can I have a template? Or can you give me a little Word document that I can fill out my information, and then I will send it to the senator or the congressman that it needs to be. And I'm pretty sure that they have, either they already have it or they'll get you something pretty quickly. I'm assuming that would have to go through the legislative committee, not the admins, right?
Right, and I can talk with the chair about that. It should just be a simple one-pager, because at this point in time, we just want to keep support, I think, for the existing language of the Senate bill, without going through a whole lot of changes. I don't know what Senator Nelson's plans are with his telecommunications project there at the Senate, but I'm pretty sure that it sounds like they've just got support for it. It's just that they want the language be integrated with some other projects that they have there. I mean, overall, the Senate and the House have been talking for years about wanting to revamp Telecommunications Act in general. And if they had just done that, maybe we wouldn't be talking about Title II today. But the bottom line is that's a major undertaking. And right now, some of these little Band-Aid repairs to try to fix areas where they've overregulated the small business unnecessarily to no real advantage to the customer. I mean, I was very clear when the last representative we met with back in the spring was Congresswoman Eshoo, and I was very clear with her staff about the fact that this is going to cost the consumer. This is going to cost the consumer in the form of regulatory compliance recovery fees. And that was really striking a chord with them, because they're having to deal with the fact that all these regulations that the FCC is imposing on carriers now is really trickling down to a bottom line cost to the customer. And my statement to them was, when the customer asks, who is this person, why do I have to pay this, we're going to direct them to you. And that's what I said to them. And you being Congress, to have them explain why they're regulating us to the point where we're having to charge the cost to the customer for no real benefit.
So one of the other things to pick up on that is that broader legislation for to kind of reverse some of the things that the FCC has done with net neutrality and with privacy may be on the table once Congress reconvenes next year. There's some back and forth over whether this would be included in an overall rewrite of the Communications Act, which would certainly employ lawyers and lobbyists for many, many years to come, or whether it would be standalone legislation. But The general view is that folks were waiting for the court order to come out before deciding whether there was a congressional solution that might need to be applied. So that's where we are now. But this being an election year with a longer recess, and these things always getting politically bogged down. I think that's going to probably wait until the new Congress is seated in January, if not later.
I've got a question for Steve. You mentioned, you threw out the perfect example. You throw these burdens that, people that have never run an ISP are telling me, oh, it'll take you 2 hours to do this work. Well, that's fine and dandy, but what if it takes 5? And you basically said, people that have never done, they're not doers, are here telling us what it'll take and what financial burden it will be on us. Are they even listening? Do they even care?
Well, I'd like to think that they listen and care. Otherwise, we'd all be wasting our time and money talking about this stuff and writing things at the FCC and having lobbyists talk to Congress and having me and Alex and others walk the halls of the FCC to bang on the table. And you kind of gave a great example, probably intentionally, maybe unintentionally, but that's exactly the issue that comes up with the outage reporting proceeding, and comments are going to be due in about a month in that proceeding. But this is where the FCC is saying, hey, broadband providers, if you have an outage, we want you to let us know online within 120 minutes, and then again, give us a status report 3 days later, and then 30 days later, tell us, what the outcome was. And the FCC has said, well, we think this is only a very small burden. They actually did put burden estimates in the NPRM, which was kind of unusual. But they disregarded information that one of the big carriers had filed. That was either AT&T and Verizon, which said this is an 11 or 12-hour thing. It's not a 2-hour thing every time it goes down. Now, let me lay a couple of other things on you. And that is that the definition of outage includes a significant degradation in service. It could include things like congestion. And the FCC is asking for comment on what would constitute, what kind of metrics and thresholds should we use to determine whether there has been a loss of functionality for a user. So it's not just when something on your network happens that takes service offline. It could be something that happens upstream or something that happens on your network that just degrades and makes it less functional for users to use.
Yeah, and just imagine, I couldn't even tell you how many WISPs are out there that we have, things like they're one-man shops or two-man shops. Mm-hmm. You don't want to sit there and stop what you're doing. You're trying to fix a problem. You're up on a tower, and now, oh wait, look, it's 100 minutes since the outage. I'm gonna have to stop, climb down my tower, and get basically get a laptop out. Try to get internet if I can, assuming that I can. Maybe I can't, because guess what? My network's down. I'm trying to fix it, and go report on it and say, hey, we have an outage. That's just definitely not doable. And I mean, I understand for a larger organization, somebody that would have somebody. I mean, you're going to end up having to hire somebody. Even with a few thousand subs, you would probably have to hire somebody just to go, your job is to sit here and wait until we have to report something. And then when we have to report it, your job is to know when to report it, how to report it, and how quickly do we report it so that we don't get fined by somebody because we didn't report something that we didn't know we needed to report. So yeah, fun stuff. Not the coolest thing in the universe, if that makes sense for a lot of people.
I mean, in the converse, say there's a person doing BitTorrent that's illegally downloading music, right? And that impacts the network.
There we go.
Can I, as an ISP, file a complaint with the FCC, and then they'll go after that person for doing it? Turn it around on, the cause of this.
Yeah, well, you may have legal ramifications based on what your bandwidth deal is with whoever it happens to be, but um, the FCC is looking at the broadband provider because big picture, they see broadband providers as being the gatekeeper or the choke point for everything that the consumer sees, and you're sort of the last line. So therefore, you have the ability to examine all the packets that they're getting. That's the privacy thing, and you have the ability to know whenever there's an outage that affects a certain amount of people for a certain amount of time on your network. Which, by the way, you might not even have that equipment, but Dennis, you framed the issue exactly the same way that WISPA is going to frame this, which means, along the lines of, hey, I just had a lightning strike. I need to climb the tower after the lightning passes to replace a radio. And you want me to stop what I'm doing so that I can go ahead and file some silly notice with the FCC. Otherwise, you guys are going to come after me. And that's the picture we're going to try and create. And, kind of taking this back up to 100,000 feet, one of the things that we said in the broadband privacy comments and the reply comments is what you guys are trying to do here is the grand slam of regulation of small providers. It's open internet under Title II. It's the enhanced disclosure requirements if those rules sunset. It's privacy rules and it's outage reporting rules. And it's death by regulation. And when you look at these things not in the tiny little silos of each proceeding, but pull back and say we've got four things going on. It's a huge problem, and it's something that we're going to have to work very hard to try to minimize.
And I
Yeah,
think we
Well,
are.
inevitably, the FCC looks things in terms of, where's the biggest effect, and everything we're talking about today, from the beginning of where Title II became a thought of being imposed on us and having us change our status to be communication carriers, were all a result of things going on at large companies. AT&T was probably the first one to hit the news when they were going to start charging for you to have access to their customer networks if you're not on their network. Paid prioritization was an AT&T term, and all the problems that they're talking about, and everything is really caused by these large carriers, and so they don't understand that a small carrier still has issues they have to deal with, but it just doesn't make any sense for us to report this information to them. We should be fixing our networks. We should be providing services, and something that Steve has mentioned before about Title II is the liability. So customer complains under Title II about having regular outages, and I haven't reported them because they didn't tell me, and it was not on my network. It was on their network, but they call it an outage. We've had probably 50 calls in the past 2 weeks from people maxing their connection out, thinking they're offline. There's too much liability for these regulations, and for a small business, it just doesn't make any sense for us to have this.
Now, let me ask this question. The reporting aspects are not. Let's try this again. The reporting aspects are not required as of yet. Is that correct?
For outage reporting, Dennis,
Yes.
or for
Yeah.
or for
outage,
other thing?
let's
For
go with
outage
outage
reporting, that's
first.
correct. Though, so the FCC has put out a notice of proposed rulemaking, and the comments are due on August 26th. And WISPA has put together kind of a small team to develop those comments. We do have an operator that's actively helping out on that, and one of the things that I need to do when we finish here is to start putting a little outline together. So then there are reply comments, and then the FCC will adopt rules. Now, the end of the year, it's widely expected that we will have regime change at the FCC. Maybe Chairman Wheeler is hoping that whoever is elected will keep him on or invite him to stay on. But that's not usually what happens, in which case, if there is no decision, it will kick to the next person. And even if there is a decision, then we would have an opportunity to seek reconsideration at the FCC with kind of a different cast of characters making that decision.
Well,
doesn't this tie into what you said before too? Part of their procedure is they got to figure out what kind of burden this is going to be before they can even implement something.
So one of the things the FCC has to do is every time they propose rules is they adopt something. It's an appendix that's stuck to the back that nobody ever reads, and it's called an initial regulatory flexibility analysis. And there's something called the Regulatory Flexibility Act that says that agencies have to consider alternatives that minimize the economic burdens on small businesses. So, of course, in this, what we call an IRFA, an IRFA, Initial Regulatory Flexibility Analysis, the FCC really didn't do its job, and they didn't even discuss the impact on small businesses very much at all. So we're going to be filing, I would anticipate, separate comments that challenge the FCC, the validity of the FCC's regulatory flexibility analysis. Basically, if they can't get that right, then their whole rulemaking process is flawed. So we did the same thing back in the open internet rules. So it's pretty much cut and paste into that. And so we'll file separate comments that gets at these small business things. But it gets me mad every time I see the FCC do a slipshod job on what it's supposed to be doing to carve out special rules for small businesses. There is an effort underway on the Hill to kind of adopt overall general legislation that would require the FCC to take the interests of small businesses into account and to defer implementation for a year. Basically, it would get us around a lot of these things by having an overall statute instead of having to argue about them in every single proceeding. So that's just sort of, on the QT up on the Hill, but it is something that's been discussed and I think vetted. There's no pending legislation right now, but something to keep your eye on.
So again, going back to this, so the reporting requirements aren't there.
Right.
They would come into effect in December if it doesn't get extended, or not?
So the outage reporting rules, we don't know when those are going to be adopted. The enhanced open internet disclosure rules will sunset in December unless they're extended. So at some point there will be some activity at the FCC around extending that termination date, that end date. And I'm not trying to scare it up at the FCC, because the closer we get to December, and without any kind of burden estimates and with Hill legislation still pending, the more likely it is that the FCC will want to extend that. So I think at some point, if we're sitting here and it's November, then we will probably want to go to the FCC and say, hey, we got this rule expiring at the end of the year, or this exemption that expires at the end of the year. Hasn't been anything happening. You guys need to kick it down the road. You really don't have an option, because one of the things that the sunset was predicated on was the fact that we would have burden estimates, and that hasn't happened, so nothing's changed, and you need to extend the exemption. So that's sort of looking into the crystal ball a little bit.
Gotcha. So that's what's going to happen. Now, as far as right now, what rules are specifically are running right now that everybody should be following, or should be at least looking at?
No blocking, no throttling, except subject to reasonable network management. No paid prioritization. You do need to have an open internet disclosure statement that complies with the rules adopted in 2010. There are a number of Title II rules, general privacy, not the specific rules that have been proposed, but Section 222. You do need to be making sure that you are not being unjust and unreasonable with your rates, charges, services, and with your rates, charges, and practices. You are subject to someone filing a complaint with the FCC or going to court and seeking damages there. There are a number of other Title II rules that the FCC did not forbear from. Let me kind of give you, so that's sort of the lay of the land in a general sense as to what you are now subject to.
There we go. I think a lot of our listeners are probably going, what should I be doing? I think this is also something else, because I talked to another WISP about maybe a week ago about this. And the specific question was, I know all this is going on, but what do I actually have to do? And his reaction was, well, it went to court, and right now we're waiting in December to see what happens. And I go, well, no, there's stuff you have to do now.
Exactly.
And you need to be aware of that. But it could be a lot worse later. We don't think it's going to be, because that's what we're here for. That's what WISPA is here for, so that we can sit there and getting that type of stuff taken care of.
So Dennis, let me kind of jump in, because I want to kind of kick this to Alex to talk about something he's been very intimately involved with, and that has to do with this consumer disclosure, otherwise known as nutrition label, that something called the Consumer Advisory Committee of the FCC put together, and it's supposed to be, quote, a safe harbor format for disclosing what your network practices are and what your speeds are. So I think it's a good opportunity for Alex to talk a little bit about what the CAC did and what they came up with. So I'm going to put you on the spot, Alex.
Yeah, thanks. So the safe harbor statement is basically the point of it is to disclose all the pertinent information to your customer who's buying services from you. And it does cover things like speed. It covers things like upfront costs, any additional costs that may be charged. So, like, for example, if you buy services and then they quote you $25 a month, but you get the bill and it's $25 a month for your internet service, but it's also a $5 modem rental fee and a $3 regulatory recovery fee, and there's usually, with some of the telephone companies, usually about $15 worth of fees that they don't disclose. It's really trying to address that. And then anything else regarding usage. So if you have a usage plan, if you're buying a $25 account and it's $10 megs per month, 10 megabit speed, but you have a cap of 100 gigs, how much is it going to cost you after that? So all these things that are related to the product that you're buying, or you're basically selling to the customer, you need to disclose so that they don't have any surprises, going forward, and that they can make an educated decision. So theoretically, if all providers provided this information when a customer was getting an estimate from provider A and B and C, they could stack them up and have a comparison. And they did refer to it as the nutritional label, because that was something that was done in the food industry, so that when you were buying products, you could take varying manufacturers and varying vendors' products. If they had a 12-ounce can of tomato sauce, you could look at the ingredients and decide which one you felt was better for you. It didn't help you with the taste, but I'm sure it helped you if you run a diet to decide which one you wanted to get. So that you could make an educated decision. So this same kind of idea is for broadband. So as a provider, I hear at least 100 calls a day. The question is, all right, well, how does this compare to my 5 gig plan? And we're talking about a 5 megabit plan. So we have to explain the difference between speed versus usage. And so a lot of times customers just don't understand that. So this hopefully should explain that if everyone employs this method. Not every ISP will use this exact same format, and how they deploy that format will be different. Some will have a static form, and some will have a form that is dynamically created online when they are getting an estimate from a customer. Not everybody will use this form. So the idea is that it's a safe harbor. If I disclose all this information and then the customer buys the product and then later discovers they didn't really understand or are not happy with something that I disclosed to them, then at least they, if they do make a complaint to the FCC, I can say, well, this is what I told them, and this is our disclosure, and so their complaint's not really valid. And that's something you kind of got to do in this environment to protect yourself. So we did post that on the members list, and if anybody wants to get a copy of that again, just hit me up at Alex P at HighSpeedLink or alex.phillips at wispa.org, and we can get you a copy of that.
Well, I'd like you all to know that my internet is gluten and sugar-free.
Yeah, there you go. That sounds good.
Hey, Alex, going back to what you talked about soliciting our congressman, I know that WISPA wants a unified message going to our senators, and if I could find a letter or get a letter, I would print it up and sign my name to it with my letterhead on it. But is there something, and Dennis kind of alluded to this, is there something that is in the works from WISPA to help us with that?
Well, not specifically right now. The legislative committee has been following this issue in D.C. and like I said, it is Senate Bill 2283. If anybody wants to look that up, so they can get some particulars. But I'll talk to our legislative chair and see if we can't get something drafted up. And legislative is legislative at wispa.org. If anybody wants to email them directly, and that'll go to the committee. If they've got any questions, and we can provide as much information as anybody wants that we have available to us.
Steve, just be careful when you say soliciting your congressman that it means what you want it to mean and not something else.
Yeah. You know exactly what I'm saying.
Oops.
I do.
I use poor language sometimes. But my internet's gluten-free.
Yeah.
And probably fiber-free too, right?
No, I'm adding fiber.
Yeah. He's going to town over there.
Yeah.
So, Alex, I thought we had. Didn't you want to say something about? I'm trying to remember the gentleman's name.
Yeah, there's a study that WISPA has been working on with the Carmel Group, and basically the Carmel Group approached us and several other of our members, and some of our members actually approached them as well. Start off the process, but there's a report that I think many of our WISP operators will find interesting. The Carmel Group is a 20-year-old consultancy focused on media and telecom, and they've been doing a report on basically the WISP or competitive broadband provider industry, and the idea there is to kind of qualify and quantify the value proposition of our industry and what we're doing and how we're doing it and why we're doing it. Some of our WISP operators are looking at growing their businesses more, and the idea being is that they may need to find funding from either banks or other financial institutions that can provide them additional revenues to grow their business faster, because it seems like there's a very big demand. So, this report has the blessing of WISPA, of course. We've been participating with them, also the WCA and other, WISP industry people. It's going to be announced at WISPApalooza this year. So this could probably be one of the best reasons to come to the WISPApalooza show is to hear about this report and see what it's available and as far as information, because it's going to make a big deal for a lot of companies who are looking at growing their business, expanding, and will need additional financing and funding from various sources as a way to justify and help them understand. Just talking with some of the larger WISPs who've been trying to push the envelope, the problem is that you look at the telephone industry, and there's plenty of books written about that, and if you look at the fiber industry, the banks understand that. But when you look at the WISP industry, it's not cellular, so they don't know what we're talking about. And so, although many of us have educated locally our banks and financial institutions and have had success, pushing that envelope a little bit more means you've got to work with some larger companies, larger banks, and they don't quite understand. The Carmel Group is a very sound consulting group, and they are recognized. So they've done a very objective study. It's not us telling them what to say. We said, well, what do you want to know? And we answered questions, and we told them what we knew. And they also went out and sought information elsewhere. And so the bottom line is that now we've got some concrete information that's valid and not biased in any means about our industry, that a bank or an investment company or just a angel investor for that matter can look at and feel confident that they understand where this industry is going. We all know, we all have those phone calls 20, 30 times a day, so we all know how many people need and want broadband from us. So maybe if they were calling the banks, they would know, but this report should help that. So I invite people to come to the WISPA Palooza this year in October. It's going to be at the Rio Hotel again in Las Vegas. A lot of good stuff on the agenda. Check out the WISPA.org website for more information. But definitely look out for this report. I think many of you will find this very valuable.
So, Alex, one other thing is that as part of the report, one of the integral parts of it, as I understand it, is going to be a survey that's going to go out to members. And please don't ignore the survey. It's about 50 questions long, and it asks you a lot of easy-to-answer questions about your network. You will be invisible, and your information will be confidential. It's only going to be used in an aggregate form, but it's really critical to provide kind of a member survey as part of as an integral part of this report. So please, when you do get that survey, take a few minutes and fill it out.
Yeah, that information will be invaluable. Sorry.
Steve, what's the estimated labor burden for filling that thing out? And number two, what?
Oh man,
don't you
come
think
on!
that this report could be helpful for our lobbyists lobbying our Congress?
So let me answer the second question first. The answer is absolutely. It will help our lobbyists and it will help me because I get questions all the time. What kind of speeds are your members pushing out there? What kind of usage caps do you guys have? What's the average size of a WISP? And those are some of the questions that are asked. How big is your network? What speeds do you do? Do you provide VoIP or just broadband? What other services do you provide? I think the answer to your question is if it takes you, I would think between 15 and 30 minutes to complete. And yeah, it's going to be really useful, not just for bankers, not just because we're interested in our industry, but it'll have real practical impact on what I do here in DC, what RE Storage, the lobbyist, does in DC, and the information that we're able to share with members of the media as well.
Yeah, I mean, just imagine if right now we can't sit there and say, hey, there are 6 million subscribers that are using WISP networks. We can't say that. We don't have a good number. And that's really that's another reason to do this, is to get that information out to the people who need it. And then whenever the media comes and says, well, you're a WISP, we don't even know what that is. Well, now all of a sudden we have a report. Here's an industry report, and it shows that we are a significant player in the unused, in both the served and unserved market space that a lot of people are taking for granted. A lot of people don't know about, and we're definitely making inroads. Since I've been a board member from the previous term as well as this term, we have made leaps and bounds differences between what we had and what we have now. And if I remember correctly, and I don't remember the exact thing, but I remember talking in a meeting, and there was a very specific item that came up that instead of the FCC going, here's our proposed rulemaking, or here's all these rules, someone from the FCC came to us and said, hey, what do you think about these rules before we propose them to the public? Do you want to chime in? That says that we're at least making some noticeable difference.
And another thing is when we are in the 1 week quiet period before the FCC adopts rules, is there have been a few times where I've received calls from the commissioners' offices and they say, all right, tell me what are the things you want, and we're going to try to negotiate these things with other offices. In a couple of cases we've been successful in doing that. So long story short is, we're stakeholders that get invited before the rulemaking comes out, and we're also involved in some of these things in the end game, and the only way you do that is by sustaining your communication and your advocacy in a very credible and professional way during the whole process.
Yeah, so there you go. Well, with that said, Steve, do you have, Steven, sorry, do you have anything else that you want to get? I have a couple items to wrap up the show with. Either Steve. Pick a Steve. I don't care.
I'll just add one thing, and that is there's discussion that the open internet order from the court may be going back to the court for rehearing, or will be going to the Supreme Court. So some folks have indicated they want to do that. Right now it's the law of the land, but and I wouldn't be too optimistic that we're going to get the court to overturn the decision or get the Supreme Court to take it, but you may see some stuff in the media over the next couple of weeks on that. So that's my sort of parting shot.
There we go. There we go. Well, I want to make sure, first off, I want to thank Steve Coran and Alex Phillips. Thank you very much. We had some technical difficulties yesterday. They still got some time today to get the show on. I think a lot of people are going to be interested. We had quite a few playbacks and concurrent viewers, etc., on the show live. What was that?
Any questions from the chat?
Nothing that I've seen. I will be glad to double check that though just before we leave here as well. The other things that I really have for everybody is some of our upcoming shows. Let me see if I have any chat questions. I don't think so, but I will double check. Nope, that's fine. Upcoming shows. So July 20. Where is this? 27th. We have Jimmy Carr. He's the WISPA state coordinator. He's coming on the show to talk about those local efforts that you can do within your state. And whenever I go back to this is actually a really good example of, hey, we need you to go to your congressmen and senators and send these letters out in support of WISPA's stance. And getting those letters to where you can easily send them out quickly and effectively, I think is really, really good for that. After that, we have Brian Smith from Advanced LLC. He's on August 3rd as well coming up. So we do have a couple really good shows for you. The very last thing, remember, WISPA-Palooza, October 11th through the 13th. There is Fiber Weekend before that, so if you would like to do that as well. The agendas have been posted. They are up there for both the Fiber Weekend and the WISPA-Palooza show. So if you would like to go or find out what is going on, those agendas are definitely up there. And of course, they're going to get massaged a little bit, but I think they're really, really good. So take a look at that. If you are not going to WISPA-Palooza, you should be. With that said, Alex, do you have any parting comments? And we'll head out.
No, I mean, I think this is a great show. I appreciate Steve, all of his work, and I appreciate you guys having this show so it gives us an opportunity to talk to the membership real time and other folks that follow the podcasts. Take advantage of us as far as talking to your senators. Let us help you, help us help you.
Excellent, Stephen. Anything else?
No, I totally agree, and hopefully we get something from WISPA to present a unified front. We're not just like we've talked about in the past, just writing off-the-cuff things to our senators, but presenting a unified front so that when these senators get together, did you get this letter? Yeah, I did too. This is a real industry. But that should be forthcoming, we hope. Well, with that, again, I want to thank Alex and Steve for being on the show. Very timely, and sorry for the technical difficulties that Dennis has had yesterday, but we got through it and listened to the show and reach out to the experts in WISPA. Well, you guys have a great week, and we will talk to you next Wednesday. See ya.
Thank you for listening to ISP Radio. We hope you've gained new insights and additional wisdom in our industry as well as your business. Please remember to visit our show sponsors via the links on ispradio.com. If you're interested in becoming a show sponsor, contact us at sales@ispradio.com. Now go out there and push those packets as fast as you can. Good luck and Godspeed.